Take over.
Come on down. Gotta be. Don't stay in the back. Too
Sure,
few
yeah,
of us.
feel free to move forward. Okay, well, thank you for coming. Thank you for those here in person, and thank you to those on Zoom. I'd like to welcome you all to the Riverside County Law Library. There are a few unfamiliar faces here. We as a library are a bit unknown. There's a much more well-known one on Main Street. There's also a jail next to us. Anyways, my name is Giannis Aitkasiazu. I'm a full-time library assistant here, and I'll be the host of tonight's discussion. I've prepared a few remarks. This is the first of hopefully many events that have to do with civics education that we'd host here. By some strange circumstance, I never took any civics classes in high school or in college. So I had never even read the Constitution until a few months ago while preparing for this panel. I read the news, I hear talk about the constitutional rights, violations of them. I hear things described as constitutional or not. But I don't really get it. I don't know what it has to do with me. So I wonder if others feel similarly. So I hope I speak for many when I ask, is the Constitution still relevant? Tonight, we have 4 panelists who will be asked questions. Following that discussion, we will open the floor to the audience to ask questions. If all goes well, the discussion will give everyone some tools for addressing tonight's big question. Is the Constitution still relevant? Without further ado, I would like to allow our panelists to introduce themselves. Please state your name, occupation, and a little bit about your interest in the Constitution. Let's start with the end with Professor Mort. Go ahead.
Good evening, Pete Mort. I was a trial lawyer for 45 years. Practiced in small town New England. Here in town, I had a law firm for about 16 years. And then I made a transition to the large international law firm where I headed litigation on the West Coast and then ultimately was on the management committee of a large international firm where I manage about 600 litigators worldwide. So I've had a varied legal career. In my retirement years, I was approached by UCR, where I and my wife had graduated from more than 50 years ago. And the school asked me to come back and teach what is called moot court, which is simulated appellate practice. We have done that class, and now we've added a second class so that UCR is competing nationally in the moot court competition. And then I also teach constitutional law, fundamental freedoms, and have taught constitutional law, criminal justice. So my interest in the law has been long and varied. Indeed, I should mention, my first trial was in 1968 in the military under the Uniform Code of Military Justice. I had not gone to college, let alone law school. But in those days, if you were a commissioned officer, you could try any case as long as the punishment did not exceed 6 months. So I actually tried cases totally incompetent. I really feel bad for the poor soldiers I defended who ended up in the brig. But I decided that I needed to learn something about law, and it has been my life passion ever since.
Well, good evening, everybody. My name is Hadley Bajramovic. We have a practice in Canyon Crest Town Center, the immigration law offices of Hadley Bajramovic. I'm from the South. You'll probably hear that in my voice. I moved to Riverside to join UCR, as a matter of fact. I was the director of the International Scholars Center. I was responsible for obtaining visas for postdoctoral scholars and professors at UCR. And after 2 or 3 years, I realized that there was a lack of immigration attorneys in the community. I think that's different now. So I started a private law firm, and the joke is I'm often called avocado Hadley because in Spanish and, French and other languages, it's abogado. And I started my practice, getting my name out there, putting up my shingle, as I say, by sitting in grocery stores, Hispanic grocery stores in the vegetable sections next to the avocados. So a lot of people call me Avocado Hadley, and avocado is for fun, and we use the green colors of the avocados in our branding. But anyway, so our law firm has grown over the years. I represent the Consulate of Guatemala. I've represented the Consulate of Mexico. I've represented now 8,000 people in the area. Yes, it's an incredible amount of work that we've done. It's administrative law, of course. It's not court. We do have a court department. We represent people in removal proceedings. We have humanitarian cases, which would basically be like asylum, U visas for the victims of qualifying crimes, VAWA for the victims of abuse by spouses. We have the family department, which would be basically family petitions. We also do business immigration for employment law visas, employment immigration visas. Like last week, big headliner was that Trump has now implemented a $100,000 fee for H-1B visas, which is like our Cadillac of immigration employment law visas. We don't know how that's going to play out yet. And let's see what else is interesting about me. Let me think. Sorry, I'm not really good at constitutional law. As a speaker, we have scholars here on the panel, but I can tell you how it's been impacted. And really, we've had a lot of issues coming up with court, mainly because of Fifth Amendment problems. The due process, the meaningful opportunity to make cases in court has been largely impacted lately. And that's what I'm here to talk about tonight, and know your rights and things that are derived from the Constitution.
Awesome, thank you. Go ahead, Mirwais.
Hi, everyone. My name is Mohammad Asef. I'm an attorney. I have my own law firm. I practice civil litigation, which usually involves contracts, disputes, employment law cases, and a little bit of personal injury. I wanted to attend this panel because I'm still very much passionate about the Constitution. I was passionate about it when I was in law school, and it is something that I cherish. I study, I research, and I write about. So hopefully you get something of value from this panel. Thank you.
Thank you.
Good evening, everyone. I'm John Cioffi, and I'm a professor in the political science department at UC Riverside. A few lifetimes ago, I was a practicing lawyer as well. On the East Coast, I clerked for a very fine federal judge and then worked as a litigation associate in one of the large law firms in New York City. Then departed for graduate school at Berkeley, and I remain with the University of California today. I've taught constitutional law for the better part of 30 years at this point. Though for reasons I'll get into in a bit, I no longer teach constitutional law. Bequeath those courses to Pete Mort. But law remains very central to what I do as a scholar, and very central to my thinking about politics in general and the politics of this particular moment in history. So my research is, broadly speaking, the intersection between law and political economy. So both constitutional levels of law, but also legislative and regulatory law as powerful frameworks of how economies are structured and how they perform. And one of the extraordinary aspects of our current moment is law seems to be disintegrating at an increasingly rapid pace, particularly in the United States. And that starts with the Constitution and constitutional institutions. So I look forward to discussing this cheery topic with all of you tonight.
All right, thank you so much for introducing yourselves. So our first question is going to be, how does the Constitution apply to your work? Go ahead, Mort.
Well, obviously, right now I'm trying to teach it, and that requires you to learn it pretty much every day because it's rapidly changing, and it's getting harder and harder to be predictive of what the law is going to be tomorrow. And I think the question actually kind of also begs an issue which you yourself have raised, Giannis, and that is the lack in our primary, secondary schools of teaching civics, government, and the basics of our constitutional frame of government. And I find that I have the great privilege of having students in my class who are hardworking, they are intelligent, and they know nothing about the subject that I am introducing to them. And that's the system's fault, not theirs. So I find it very rewarding to be able to share with them my own views on the Constitution, and then working that into the moot court program, which most of you would not know, but that is a program whereby students are taught legal research writing, and they actually prepare an appellate brief as if they were filing it in the Supreme Court. They argue that case before judges in a simulated trial or appellate practice hearing. And so they get great exposure to it. And I'm happy to say many then go on and pursue careers in law, not always as lawyers, but in law-related subjects. Let me also make the caveat that I should have started with, and that is very happy to be here this evening and share with you my views. I am not speaking on behalf of UCR. And I need to make that disclaimer. But I get much, more freedom here to speak than I perhaps do in the context even of academic freedom, which is itself a subject of constitutional debate as to what academic freedom even is anymore. But John and I are both in that circumstance where we are, currently teaching at UCR, so our comments are our own. Is that enough for that question?
Yeah, go ahead and give your answer, Hadley. Thank you, Mort.
Thank you. Well, as I've said, I'm a little outside of my comfort zone because I'm not a constitutional scholar, and being on this panel is intimidating. But I can tell you that immigration law is federal law. I don't believe, gentlemen, maybe you can correct me, that the immigration law, the power of the federal government over immigration law is not specifically enumerated in the Constitution, but maybe derived from clauses such as the naturalization clause and commerce clause. Everything comes from the commerce clause, pretty much. That's what they told me when I was studying for the bar. Go for the commerce clause, sovereignty clause to protect the borders, necessary and proper, which is more like an enforcement clause. But it all was, I think, codified is the right word in the Immigration and Nationality Act of 1952. And because of the INA, I'm able to practice here. My license is actually from Tennessee. And the INA gives immigration attorneys the right to practice anywhere in the United States as long as they are licensed in the highest court of the land. So you have a lot of attorneys in California and across the United States that are not licensed in the state where they practice, which is not what you see in other forms of law, maybe like litigation
Great.
and divorce law. And so that is why I'm able to have a private practice here. And what we're seeing right now with the Trump administration, and I mean, you know, I don't have any problems speaking my mind. I just hope not to offend anybody, but as an immigration attorney, I think you guys know where my political sympathies lie. We are facing a crisis. We consider this war. We, in our immigration courts, are seeing a deterioration of due process rights for our clients. For example, immigration judges are not letting us move forward with applications for relief. We call it pre-termission or pre-termit. Applications for relief, our clients may be eligible for asylum, for example, but the judge will do, I think it's akin to summary judgment without even having an argument. They just decide on their own, oh, this is not a good asylum case, so we are going to pre-termit this application and order this individual removed. And so it's, to say the least, disheartening for us. The immigration attorneys are fleeing immigration law and PACs because, you know, you mentioned the predictive powers. We're losing them. We don't know how to advise our clients when we don't know how an immigration judge is going to rule when they're not ruling based on Fifth Amendment rights to have a, you know, a meaningful opportunity to present a case. But there are other ways that the Constitution does affect us. We due process meaning the main way the Constitution affects us in other like crimmigration matters where you have a criminal issue. Somebody may have a plea deal and have pled to a deal with the DA's office and may not have been advised on the immigration consequences of that plea deal, and that is considered to be a violation of due process. That's just another example of how the Constitution affects us. It really, it permeates all of immigration law, but I'm trying to give you guys examples, specific examples. I think also states' rights versus federal rights. Is that a constitutional issue, guys?
Yeah,
Well,
Sure. yeah.
okay.
Federal.
Well, I'm not, you know, it's been 20 years, something like that, since I'm in con law. But, you know, one thing that I think we can all relate to right now is the No Secret Police Act that was signed last week by Governor Newsom. And I believe that will be challenged because of an encroachment, the state's encroachment on the federal power to govern immigration. So we'll see that play out. And it also played out today on DACA. I don't know if you guys are following DACA, but there's a judge in Texas who, you know, allowed an injunction to go into place to stop initial DACA. It's been 8 or 9 years now, and a final order is going to go into place, and our initial DACA applications will resume, except for Texas, because Texas was able to show that the procurement of driver's license caused an injury to the state of Texas, but ultimately it was decided that Texas could not prevent the entire nation from receiving DACA. So those are just some of the examples of the way, you know, my office is, our practice, immigration laws affected by the Constitution. But I'll be glad to answer questions about that more when we get into the questions.
Yeah, that's great. Thank you so much, Hadley. Go ahead. Go ahead, Ross.
Well, the Constitution, thank you so much. The Constitution does not directly impact my work a lot. Civil litigation is something that is more about the state law and common law. But still, the Constitution provides the main parameters of, you know, due process, the right to notice, the procedure that you follow. So although it does not directly impact my line of work, there are still concerns that maybe sometimes it'll become an issue. Notice is one of the issues. We have some cases where if a person is not properly notified, they could default judgment against them. Then it's if they didn't receive a proper notice, then it can become a constitutional law issue, but it's very rare. All right.
All right, then go ahead, Professor Cioffi.
Sure. Well, as I mentioned initially, I've taught constitutional law for many years, but I no longer do so. And the reason is this. I taught that class as an introduction to legal argumentation and analysis for undergraduates who were thinking of law school, who generally know absolutely nothing about law. And if there's a possibility of having negative knowledge, they have negative knowledge of what it's like to actually practice law. So I wanted to give them those, kind of intellectual and cognitive foundations and a taste of what's to come in even, more intense and harsher fashion. So they know what was coming. And that requires, teaching things in terms of the theories of argumentation, theories underlying substantive interpretation of legal text, particularly the Constitution, and the kind of logical structure of legal doctrine. And in the last 10 years or so, those intellectual foundations, both theoretical and doctrinal, have simply been disintegrating until it became a fool's errand to try to tell students that, well, here's this established framework of understandings that renders law and legal decision making predictable, particularly at the Supreme Court level, which, if you're teaching con law, is most of what you're looking at. So now I teach judicial politics. I teach many of the same cases, but from a very different vantage point, and it situates those old cases in the political and historical context of their times, and then updates them to the present, where we no longer have really anything to grab onto except for the political exigencies and interests that are shaping decision making. Which works just fine, but it performs a very different function in terms of scholarship and in terms of pedagogy. Similar to Pete, I have these students they're very self-selected, because generally the people who come to take my class in judicial politics still want to go to law school. So they have that initial interest, and the last couple of years, they've also been incredibly engaged because, to put it colloquially, they're freaking out. So last spring, I taught this class, and every single session, I would begin by what has happened since our last class. And there was always something extraordinary and significant and disturbing. So made for great classroom teaching, makes for really bad politics in law. So the other big thing of how Constitution and its transformation has affected me at work is the university is under attack. Very, very, in a predictable fashion. We have not yet been attacked at UCR. We are not visible enough. So this is predictable through a political lens and a PR lens, and not through a legal lens. So what I've seen is the administration has attacked highly visible universities in order of how likely they are to roll over. They've made some missteps in those assessments, leading to constitutional litigation, and these are egregiously unconstitutional assaults on academic freedom and institutional autonomy, and they've been held as such by the lower courts. But the campaign continues. So we're all kind of waiting for the blade to drop, regardless of what university we're at. So,
John, did you just say I was the fool on an errand? I think it's what you just said.
but
That's what I heard.
you conceded that it's very difficult to predict. So if you were using
Uh,
my criteria of what I was trying to do, that became impossible increasingly.
Well, it seems like there's some agreement that at least from a legal perspective, I like how you put that, things are becoming unpredictable. So this will lead to my next question. Seems like the Constitution is changing all the time. What's going on? We can move backwards this time. We'll start with you, Professor Cioffi. And we'll
All
move
right.
the other way. Keep you on your toes.
So that's a very, very big question.
Okay.
And there are a couple of primary moving parts that need to be identified. One, there's been a concerted campaign for at least 40 years from the right to capture the courts. Really since the 1980s, the right has succeeded mightily in expanding its power in the executive branch and the legislature. They have forced the Democratic Party to the right. And the courts were the big institution still standing in their way. There are also very, very significant economic interests at play. So it does not stop at the Constitution. The whole rhetoric and kind of manufactured moral panic about the tort explosion. You can't do anything without violating a regulation. These are well-funded campaigns, and they're not there to make sure that you can build a playground. They're there to deal with the liability exposure of very large corporations, in the aggregate dealing with very large numbers. So there's that. That has been largely successful, much more successful at the very top of the judiciary than as you go down. And also the kind of people who've been appointed higher up are much more highly politicized. This is why you see this very interesting pattern in the litigation against the Trump administration, that they lose almost every case at the district court level over and over again, over 95% failure rate. As they go up, they start to win. And that's very variable depending on the circuit. During the Fifth Circuit, they get a much better shot than the Ninth Circuit. And then they have a much, much better shot in the Supreme Court, which has also expanded its use of what's called the shadow docket, which is basically to overrule the lower court opinions without an opinion of the court itself pending disposition of a petition to the Supreme Court, which is an extraordinary inversion of what the procedure is supposed to do. And this is Civil Procedure 101. Why do you introduce an emergency stay? It's to prevent irreparable harm. That's why the basis of a TRO, it's the basis of a preliminary injunction. This is the inverse. These are uses of the emergency stay that create irreparable harm, changes the facts on the ground legally and politically, and it may be years before there's actually a ruling, if there's ever a ruling. That can't be justified using any pre-existing legal principles. And it doesn't run on legal principles since there are generally no opinions. Just recently, there's an exception to that in the Los Angeles case dealing with the behavior of ICE, racially profiling people in their detentions, or rather abductions, where for some unfathomable reason, Justice Kavanaugh wrote an opinion explaining why this was okay. Basically trying to cram ICE detentions and incarcerations into Terry stop law, which is kind of like manufacturing facts and ignoring what available information is out there. It's also saying the quiet part out loud. And it makes one wonder, what part of the term shadow docket did he not understand? You're not supposed to say anything. But it let kind of the cat out of the bag, and this has been happening at a record pace. This has never happened before in American legal history. And that's very dangerous. The other big part is not related to the courts, but related to what is really the heart of the Constitution. Every time I would teach constitutional law, the first question I would ask the class is, first thing that comes to your mind when I say the word Constitution, what do you think of? At least 90% of the people in my classes would think rights. That's getting it backwards. The fundamental importance of the Constitution is a charter and blueprint of government. And that is also what is disintegrating. And that's even more troubling. The courts and judicial review are there as a last stop and backstop for the malfunctioning of government. But it is profoundly malfunctioning now for a variety of long-term reasons that are very deeply rooted in political dynamics. But having both the institutional malfunction of constitutional government and the malfunction of the legal and constitutional jurisprudential parts of checks and balances means we're in a very, very dangerous situation right now. I should mention that we just had as far as I know, unprecedented meeting of all the top military officers of the United States, in which the United States president said that they should use American cities as training grounds. That is a deep crisis. There's no garnishing over that.
Sounds that way. All right. Thank you.
All right. Why the Constitution seems to be changing all the time? Well, for me, it's a little bit different. It has been changing forever, for decades. I think the crux of the matter is that for decades, the Supreme Court justices and lower court judges have adhered to a doctrine, or I say, or a method of interpretation of the Constitution called the living Constitution. Because of that, it's defined as by Professor David Strauss. He defines living Constitution, and I quote, one that evolves, changes over time, and adapts to new circumstances without being formally amended. That last part is without the people actually getting to vote to amend the Constitution, in other words, being amended by the court. The reason the Constitution keeps changing is because of adherence to this doctrine, where you have a Constitution that always is supposed to change based on how the judges think an issue is. Conversely, the competing doctrine that it didn't have a lot of it doesn't have a lot of support. It is promulgated by late Justice Scalia, and that is the textualism originalism a doctrine, which I, quite frankly, personally, I think it's the true way of looking at the Constitution. Under that doctrine, you have a text that in its full context, I'll quote it rather, it's much better that way from his book. So in their full context, words mean what they convey to reasonable people at the time they were written, with the understanding that general terms may embrace later technological innovations. Here, we interpret the Constitution, or we should interpret the Constitution in a manner that was understood at the time that it was adopted. Once you do that, there is not a lot of room for changes. If the First Amendment meant to protect, let's say, political speech, it will always protect political speech. But once you adhere to the living Constitution doctrine, then today even my speech today, if somebody doesn't like it, they may censor it because it's a new day for a person who adheres to living constitution doctrine. It's exactly happening in England. You had a right to write something on the internet freely, something that, political, but today you may not. There are laws that can censor that speech. The reason is there is no written, England doesn't have a written constitution, as far as I know. There is no set protections or rules that protect that kind of speech. And unfortunately, the living constitution has been in style for a very long time in this country, and that's why I think the constitution always changes.
Thank you so much. Go ahead, Hadley.
Well, for me, again, not a scholar, and I'd love to hear the views of the professors at the table of what's happening to us in immigration. But my job is to deal, I'm face to face with the different agencies that enforce or make decisions or in immigration law, like the Executive Office of Immigration Review, which is the court agency, the USCIS, which is our administrative agency, and I'm sorry, I just drew a blank, but I face those officers and those adjudicators daily. I don't deal with post-decision relief, which is where constitutional arguments really come into play, like how a decision violated the Constitution or how somebody was not given their due process is mainly what we look at. And I think that you can see how these things are playing out in the news every day. I already mentioned that. The example that came out today were the students that were put into removal proceedings because of their position on Palestine. They were taken into removal proceedings, and the courts today, and I haven't read exactly what the decision was, found that that was a violation of First Amendment rights, and you can't target people for immigration purposes for their right to freedom of speech. And then, so for immigration law, it's like a daily thing. It's like Professor Cioffi, is that, I'm sorry. Cioffi, said, it's like what happened last week is totally different than this week for immigration law as well. But you're talking about economic interests. We are seeing detainees being held for extraordinary periods of time once they're detained. And that's due to economic interest because the facilities that they're being detained in are private facilities. And where an individual who is detained would normally get an audience with an immigration judge in 3 weeks, we're seeing those periods extended to 3 to 4 months. And we have different groups like the ACLU and different advocacy groups and coalitions of attorneys filing for habeas corpus. I know the ACLU is challenging Trump policy that if an undocumented person did not arrive with a visa, or what we call it, with inspection, is not eligible for bond. So most of the people that I work with did not arrive with status. They crossed through the desert or, through some means of we call them coyotes. And those people who are detained are not eligible for bond and may not be eligible for a 240 removal proceeding. So that's something that we're dealing with. A violation of constitutional rights. And also we're dealing with different organizations doing know your rights type seminars who, are sometimes missing the point on what know your rights are for immigration. That's constantly changing the way we advise the community, given the recent decision to allow for ICE to racially profile. I think that's what you're getting to, if the skin color is the basis of detaining somebody now. So, my world is totally consumed by this problem and the way the administration is using the executive power and federal powers to do things immediately, quickly, where we don't have really the way to fight at the level that I'm working at. Again, like dealing directly with a USCIS officer or a judge at my level. And then we hope over time at the appellate levels that, you know, the decisions and the things that are happening now will be properly put back to normal. We in California, if we are going to appeal an immigration judge decision, we'll go to the Board of Immigration Appeals, and then we can file writs with the Ninth Circuit if we have jurisdiction for that. And that's where I hope this will play out in the long run.
All right, thank you so much. Go ahead, close us out, Mort.
Well, I'd like to spend the next 2 hours debating with my colleague about originalism versus a living constitution. And I would start with the Second Amendment issue, where Scalia, the one who returned originalism to us, struck out a part, the first clause of the Second Amendment. Somehow that wasn't very original, but I digress. I'd like to put a little bit of meat on the bones of a comment by two of the other panelists, because sometimes we have the tendency, when we're very familiar with something, we don't take the time to, we assume you know. So let me give you a couple of facts that maybe will help you. What John and Hadley were referring to was the case that came down September 8th, and where ICE was in Los Angeles, and they had gone to a particular location, and the ICE raid occurred. And the issue is whether or not, we start with a basic concept under the Fourth Amendment, not the Fifth, which has to do with unreasonable search and seizures. And the first issue is, well, were these people seized? And the test of that is pretty easy, is, do you think you can leave? Well, if you can't leave, you've been seized. So that triggered a Fourth Amendment issue. And in the Fourth Amendment, we don't talk about citizens, we talk about people. And you'll see sometimes in the Constitution it refers to persons or people, other times it's specific about citizens. I say that to give you the understanding that people have certain rights under the Fourth Amendment to the Constitution when they are seized, not free to leave. What the court says, Kavanaugh says, basically is that the factors that the ICE agent may consider in seizing an individual is their apparent race or ethnicity, whether they spoke Spanish or English with an accent, the type of location at which they were found, i.e. a car wash or a bus stop or Home Depot, and the type of job they appeared to work. And on that basis, you could stop everybody who's there. The whole idea of the Fourth Amendment was an individual right. Can they arrest you? Do they have, it's not probable cause under these circumstances, but it's a reasonable suspicion that you are an illegal in this country. Instead, what the court has said, well, if you're in a group that looks like that, let's just stop the whole group. And then Kavanaugh goes on to say, and it's not a big deal. First of all, they probably don't have any, real standing to even get an injunction here, because you can't prove it's going to happen tomorrow. All you have to do is put your blinders on, don't read the news, don't listen to anything, and maybe it won't happen tomorrow. So let me give you one other caveat that wasn't mentioned about the reason it wasn't a big deal is they only stopped him for a few minutes, then they let him go. Well, a few days later, a lawsuit was filed in Los Angeles. The fellow owned a car wash, 79 years of age, with a bad heart condition and a US citizen. ICE went to the car wash because that's one of those locations, right? When they arrive, the owner of the car wash goes out to show the documentation of his employees. He told them he had a heart condition. They grabbed him, shoved him to the ground, He suffered broken ribs, trauma to his chest, brain injury, and was held for 12 hours without seeing anybody, not a doctor, not a lawyer. That's that little, oh, it's only a 10-minute stop. This is the level of outrageousness that we are facing today. And I don't care what side you are on politically, whether you want to focus on an individual's right or the overall constitutional protections that I love to talk about a little bit more. But this is just one example of how we see power being abused, and our constitutional protectors, the Supreme Court of the United States, gutting that individual protection and thus the protection for all.
Thank you so much. Well, I'm a bit surprised at the kind of bleak and dark turn that some of these answers have gotten. So I kind of want to return, maybe picking up off of this originalism discussion, but I do want to return to some of the origins of the Constitution with this question, which is, what remains revolutionary about the Constitution? Yeah, we'll start with go ahead, Professor Mort. Kick us off with that. And this question will close out the panel. This will be our last question that will be addressed.
Given you're only having read the Constitution recently, I've taken the oath to support and defend the Constitution 21 times. I've taken it in the military. I've taken it as a professor. I've taken it as a lawyer. So I feel pretty close to it, but maybe it helps to drop back for a moment. Let me just give you some fundamentals, if you will. Benjamin Franklin was the host of the Grand Convention, or what we call the Constitutional Convention. And as he was leaving the last day, Mrs. Powell approached him and she said, "Well, doctor, what have we got? A republic or a monarchy?" That was the issue that they were debating, a republic or a monarchy. They weren't saying democracy. Democracy does not appear in the Constitution because democracy meant direct democracy. People have the direct vote. But rather, they talked about a republic. And he says, "It's a republic, madam, if we can keep it." And she says, "Well, doctor, why wouldn't we keep it?" And Franklin said, "Because the people, upon tasting the dish, are prone to eat too much of it." What is the dish of which he spoke? I believe, and I think some scholars may disagree, perhaps others here would disagree. I believe the power, that what he spoke about as the dish was power. Was power. And that the Constitution itself is an attempt to regulate power. I'm going to cheat for a moment, because I think to understand that, you need to understand what the term republic means. Democracy, you all heard, it's used all the time. But what is a republic? A republic means power ultimately comes from the people, that the representatives, it is representative democracy, that the citizens elect the representative. So the ultimate power is the citizens, but they're electing people to act on their behalf. That's part of what a republic is. And you have a non-hereditary head of state, i.e., you have a check upon the executive branch. You have an elected president. And most importantly, a republic requires you to have a constitution, because the Constitution is the rule of law. So when we think about our Constitution today, we should be thinking of, is it fulfilling the four elements of a republic? And then we would look and say, well, do we have free and fair elections, or is that being infringed upon? Do we have an executive that's being checked? Do we have a court which is enunciating the rule of law for all of us to follow? And if we don't have those things, then we are in trouble. And the answers to that are what we're all going to struggle with. Some of us would say the answer to when you have a problem in a republic is more democracy, not less. That we need to speak out more often. That yes, we have a problem with the Supreme Court, but we need to file suit after suit after suit and keep using the system. Because if we don't use it, it will die on the vine. That we need to stand up and use our First Amendment rights. On the 18th, I'll go to my 6th rally. I hope you all are going to them. Will you make any difference as one? No. But when 5 million show up, you make a difference. And there is another theory of government that I just mentioned. We've heard, and I'm sure everybody here heard, checks and balances. When one branch of government abuses power, the other branch is to check it. But what you haven't heard about as much is what we call the vacuum theory. When one branch fails to act, fails to do their job, another branch will step in. We have a Congress that has failed to act, and therefore the executive has grown stronger. We have a Supreme Court that is failing to act. That's a vacuum. It's being filled, as it would be under any political organization, any political party. It's being filled by the executive branch. So we need to check upon that. Sorry to be too much of the professor, but I think getting the basics down gives you context for these discussions.
Great, thank you so much.
I love you being the professor.
Well, he's the real one. I'm just like,
Well, both of you, for me, I don't know about the positive revolutionary aspects of the Constitution right now. I guess I can say, as being a lawyer and having gone to law school and being educated to love the Constitution, where I just have hope in it, and that through the Constitution and through the judicial branch, we're going to survive this. And that's all I have to say.
Thank you so much.
Well, what remains revolutionary about the Constitution? Well, I would like everybody to understand that this is a very unique document. You don't have it anywhere around the world, okay? I come from a country that has seen oppression, I came from Afghanistan. Oppression all the way through. And just last night, they have announced, or the other day, they have announced that they have a complete blackout over there. No internet services, no communication whatsoever for anyone. Countries like that, they have one problem. They don't have what you have here, is the Constitution. And what I mean by that is specifically the core of the Constitution, the checks and balances, the sound, balanced federalism here, and separation of powers. Those three main things. Those countries like Afghanistan, unfortunately, they don't know how to distribute power, how to separate power, how to check it. They have never been able to do that for hundreds of years of their history. In America, you have that. You have 250 years or so. You have a document that makes sure that the power does not get concentrated in one part of the government. I still think that it's very, very relevant. The reason, and I'll pick up from Professor Cioffi's comment that he stated at the beginning. We also we have to be mindful of what really means when we say Constitution. People easily go to the Bill of Rights, but let me tell you, Bill of Rights. As much as I have lived in a country that is very, very oppressed, a Bill of Rights will never protect you. It will not protect you from tyranny. What protects you is the core Constitution prior to that, the 10th or the 12th Amendments. And that, as I said, those three core constitutional concepts: checks and balances, separation of powers, and federalism. If the Bill of Rights was protecting people, they would have protected them in countries like Soviet Union. I will give you an example here. I researched it last night. You know, the 1936 Constitution of the Soviet Union, under Stalin, this was adopted under Stalin. It's a huge constitution. It has 146 articles. Compare that to our Constitution, it's 7 articles and 27 amendments. So if you look at the Stalin's Constitution, 1936, in Chapter 10, they entitled it Fundamental Rights and Duties of Citizens. There you will have at least 16 fundamental rights for almost everything, including fundamental right to health, education, which, by the way, are not our fundamental rights here. Okay? So why they ended up with not having any one of these? The reason is, one main reason is that they did not have the concept of separation of powers and sound checks and balances, and federalism. That is not the main one, but those two. They did not have that. They did not have what the Constitution of the United States have. So I will put a caveat here for people who may want to research a little bit more. You know, if you Google it or something, you may come across the constitutions of different countries where it says, yeah, we have a separation of power here. We have a judiciary, we have an executive, we have a parliament here, we have a legislative here. But don't be fooled by that. Okay, these countries do not really separate powers. So you would have to dig a little bit more to see what the conduct of the government in those countries are. If the president is signing an order that has legislative power in it, you don't have separation of powers. You don't have true separation of powers. So that's why those countries remain in tyranny. Those countries remain under despotic ruling, and it has been like that for years. So for us, I think what needs to be cherished all the time, no matter what is going on, is you have a document that is unique in the separation of powers within the government and providing checks and balances on those powers. And less relevant, I say, is a balanced federalism, which is a little bit longer discussion, but that's also part of it.
All right, thank you so much. Go ahead, Professor Cioffi. Close us out.
I was going to use the Stalinist constitution too. Yeah, it's a wonderful irony. But well, let me answer your question directly first. The Constitution is not revolutionary. Any constitution worthy of the name is inherently non-revolutionary because it is constitutive of a form of government that can self-reproduce. When I first took con law in law school ages ago, I remember reading a line that the Declaration of Independence was the brief. The Constitution was the opinion. The Declaration's in poetry. Constitution is in prose. They're very different activities and are very critically important in their own respects. You know, constitutions, to follow up on one of Pete's points, do two things simultaneously. They constitute the framework of government and they provide the foundation of the rule of law so that you have a government under the rule of law. Both things are essential to a democratic republic. To compare it to, for example, the Soviet Union, those forms of government have one additional dimension, which is the party is superior and has primacy over the law with predictable outcomes. It's true of communism, it's true of fascism. Now, the separation of powers and checks and balances isn't entirely unique to the United States. It was arguably the first, at least in its modern sense. Other constitutions of democratic countries or reasonably democratic countries have different mixes of structures of government to provide the same functions. And it's worth noting, and I'm a comparativist. I just don't study the United States. I study comparative politics. One thing that is very clear, nobody's copying the American Constitution. Um, and there are very good reasons for that. It's a very problematic document in modern times. And this is one of our problems, quite frankly. This is a late 18th century document that was in the political avant-garde of its time. But it's no longer in the avant-garde, and increasingly we have to wonder if it's fit for purpose. The form of government, the electoral system, the way that the legislature is structured, the way that the party system emerges out of the constitutional structure as it exists. All these are deeply, deeply problematic, and we are now, basically reaping what we've sowed. And to follow up on the comment about the Constitution is always changing, well, that's actually, in an odd way, a reflection of some of the deficiencies of the Constitution itself. The reinterpretation of the Constitution in very significant fundamental ways is kind of a pressure valve because it's so difficult to amend. If you have a virtually unamendable document, when the political system goes into crisis, which we've experienced, on multiple historical occasions, you need some other mechanism for the political system to adapt. And reinterpretation through the judiciary has been one of the primary mechanisms. So the Constitution we've had up until very recently was profoundly shaped by two historical moments of reinterpretation. One was the New Deal crisis. So you said, well, everything's under the Commerce Clause. Didn't used to be that way. The Commerce Clause was read extremely narrowly, and in the wake of industrialization, it causes a mammoth political crisis and economic crisis that could not be governed and adjusted to. And that precipitates a constitutional crisis. The other great moment is the civil rights movement and the Warren Court, which actually gives life to the actual amendments created in the wake of another constitutional crisis, the Civil War. They actually, breathe new life, or life for the first time, into the Reconstruction Amendments, most importantly, the 14th Amendment, which really is transformative. That would not have come out of the amendment process. That would have been impossible. And certainly that could have tipped the entire political system into hopeless instability in the 1930s, for example, heading into the Second World War. What would have happened had the civil rights movement been blocked? Well, we don't know. That's a difficult counterfactual. Maybe we will now rerun the experiment and see what will happen, since a lot of those doctrines are now being dismantled. And that includes some of the New Deal jurisprudence dealing with the Commerce Clause. So, for example, the Obamacare case got a lot of press, where the Supreme Court upheld a big chunk of Obamacare on the theory that it wasn't a commerce power that was being exercised, it was the tax power. That if you had to buy insurance, well, that was actually a tax, not an exercise of commercial regulation. So the first part of that opinion basically rewrites 60 to 70 years of Commerce Clause jurisprudence. The court has not pushed that to its logical limits, but the power is in reserve. And this reflects something that's been, percolating for decades, which is called the Constitution in exile. That there are political activists that believe that the country took a wrong turn during the New Deal, and that basically constitutional law and politics should be rewound prior to 1933. So that's a fairly radical position. Now that is arguably revolutionary. But the way in which the Constitution is developed over time is a product of its own structural and institutional characteristics. If it's read too rigidly, it will break. And what is going on right now, you could say, well, it looks like we're rigidifying it. But something else is actually happening, which is very interesting. If you read the opinions coming out of the Supreme Court on the really major issues, so presidential immunity, for example, or review of administrative agency rulemaking. On the one hand, precedents are being eliminated by the score. Entirely new legal concepts of, for example, massive expansion of presidential immunity are being invented. But there's a common characteristic that runs through all of these cases. They articulate extremely vague legal standards, which makes the predictive capacity of people reading the opinions and having to apply them and respond to them almost impossible. But at the same time, what does a vague legal standard do? It gives enormous power to the legal decision maker, so that the Supreme Court can take these vague standards and just mold them like putty to suit each individual case as they see fit. Which is contrary to the very fundamental notion of the rule of law as being a predictable constraint. But in a weird way, it reintroduces flexibility to the system that maintains some capacity for adaptation. The question is, do you trust the people wielding those powers of adaptation, and to what ends will the adaptations be put? That's an ongoing story. There you go.
Alrighty then. So that concludes my questions. Now we're going to open it up to the public. Going to bring the mic up to the center. Just go ahead and raise your hand if you have a question. Keep your questions short, like 15 seconds. I will snatch the mic out of your hand if you go on for too long. And also be clear about who you're asking. So yeah, does anybody have any questions? Yeah, come up.
Thank you for having us. Is that working? And thank you for joining us today. I like the compassion or the passion that you guys have for the topic. My question to you is, which constitution are we talking about? I've heard there's 3. Are we all confused as to which one we're talking about?
You're looking at me. So I will ask you, I'm not sure what 3 you're referring to.
Thank you. So he said that there's a living constitution.
Oh,
The
okay.
Constitution for the United States and the Constitution of the United States. How do we all know what it's very vague. So when you said vague, I meant void. So if everybody is confused, where isn't that the first challenge where if we can't see past the first question, why do we go to the second question? All right, thank you.
Well, I'll attempt an answer to say that in my mind, the written Constitution is clear as to which one is in writing. And the originalism would say that we don't need to go any further, but then how do you know what was in the minds of the originators 250 years ago? And people have, I think, selectively decided. Some will say, well, it's what was in the minds of those who adopted it, not those who drafted it. Others would say it was from the sources from which it was obtained, being state constitutions. But we know what the written document says. You can, look that one up. Has that document changed such that we have a whole body of constitutional law? Sure. That's a whole issue of what the courts have done from the Supreme Court on down to the implementation by a district court or Riverside Superior Court, which itself all take an oath with respect to the federal constitution, not only state constitutions. And so you have an entire body of law that stems from that original document and finds its legitimacy in that document. Because if it's not, it's that very document that the Supreme Court will rule on and say, well, this rule that you've now enacted is not consistent with that basic document. So I'm not sure that answers your question, but that's how I would attempt to answer it.
All right, thank you.
Let
do you
me,
want to say-
yeah, I do. When we're talking about things like the living constitution or originalism, those are theories of interpretation, not to be confused with the Constitution itself. To complicate matters a little bit more, there's the written Constitution, but what most people, including the Supreme Court, would regard as part and parcel of the Constitution is its interpretation, what it means with respect to specific issues. Let me give you a very, an important historical example where this was made explicit. In the civil rights era following Brown versus Board of Education, there was massive resistance to desegregation throughout the South. And one of the litigation tactics was, well, that was a case dealing with Topeka, Kansas, not Mobile, Alabama, or Montgomery, or Jackson, Mississippi. And the Supreme Court said, our interpretations of the constitutional text are co-equal with the text itself. Basically saying, stop making these spurious arguments. It applies to Topeka, it applies to you. Induced by extreme circumstances, but as a philosophical matter, you got the interpretation and the document that really are, in a practical sense, on an equal footing. Because what happens to you in interacting with courts or other parts of the government hinges upon that interpretation. But, well, I disagree with the interpretation. That will not work very well if you're dealing with a government agency, right? Historically, we've had different constitutions, I would say. And we are now in another phase. The characteristics of this one is that we're faced with increasing uncertainty and indeterminacy. What does it mean? Well, who knows? Because the legal standards and legal categories are so vague. And that is a very fundamental problem of both law and politics.
As a caveat, by the way, Mort on Brown versus Board of Education, it also only applied to education. It was only the integration of schools, nothing else. But we had to expand it for its basic underlying principle.
All right.
Thank you. And thank you all for your time tonight. I'll be honest, I'm still trying to formulate, and I've been thinking as I was hearing the response to the previous question, how to frame my question. And I'm still working on that. So I'm going to kind of maybe leave it as a open-ended, kind of get your thoughts on where my mind was. And really what it comes down to is the politicization of the topic of the Constitution and the laws and the implementation through, like, say, immigration and other topics, right? And I certainly hear loud and clear the perspective that you guys have brought to the table about the dangers and of what has been happening recently as it affects or is affected by constitutional law. And I'll try to get more to the point. I think if you look across time, what I've observed is, like, right now, for example, there's a lot of concern with what the administration's doing and how it is or isn't, depending on who you talk to, consistent with applicable law. And if I think back, to the prior administration, there were the same conversations happening and the same freakouts happening, but on the other side of the aisle, right? About what that administration was doing. And I think this is what's important to me, and maybe I'd like to hear your thoughts on, is where the Constitution provides kind of a rudder as time goes forward to keep some consistency, given the fact that there are political winds that, depending on who's in power, might try to pull us one direction or the other, right or wrong on that, right? Whether you agree or disagree with those directions. I was hearing some talk about the fact that it needs to change with time, and your thoughts on that.
Just real quick, forgot to mention this. If you're tuning in on Zoom and you have questions, we will get to you.
I'll let him to answer that. Thank you for your question. Yes, so there is a concern even within the it's not only political, but it's also with regards to the interpretation of the Constitution, there is two sides, as I mentioned early, and also the concern about predictability of the law, what is protected speech, or what is protected under the Constitution or not. Well, how do you get predictability? The best way to get predictability is to interpret the words consistently as they meant when they were originally adopted. That's the only way to get consistency and predictability. I haven't read Justice Kavanaugh's recent opinions. As much as I've read his previous opinions, and I think, but anyways, so he is an adherent of the textualism, originalism doctrine. And it seems like recently what he has done is the opposite. Okay, and that's how it feels like when you see that the justices who are supposed to interpret the Constitution based on textualism doctrine, they do the living Constitution, or they interpret the Constitution based on that theory. This is what happens. Vagueness and predictability, all of this is a direct result of interpreting the Constitution in a living manner, allowing the unelected justices to come up with anything essentially that they think is true for that day. Okay, so I believe the best way to make sure what the Constitution means every day for us is to interpret it consistently within the meaning within the meaning of the words that are written within the context and the way it was understood. I think that's the only way. There is no any other.
Yeah, if anyone, Mort, did you want to jump in?
I always hate the issue of, well, the other side does it too. Because it basically says two wrongs don't make a right. And so I never particularly like that. But to say that one side is pure and the other side is evil is not fair either. Well, we hope that the reason that Lady Justice is supposed to wear the blindfold is so those decisions are made independent of the party, their political views, their color, their race, etc. But if you go over to the Riverside County Courthouse, go look at Lady Justice. There's a statue out in front. She has no blindfold. She sees all. So it is difficult to administer justice equally. That doesn't mean that we should give up trying. This is not a particularly constitutional issue, but to me, one of the problems we have today. Well, let me put it this way. Have any of you served on a jury? Okay. For those of you who have, you know what voir dire is. The lawyers ask you questions. Do you know what the term voir dire means? It means to speak the truth. It means speak the truth. In other words, when we entrust in one of the most democratic things in our entire universe of law, we ask a jury to make a decision about what the truth is. We first demand that they speak the truth. In other words, those who administer justice need to speak truth. Those in power need to speak truth. We're not going to enforce it through the Constitution, but we can enforce it as a society that we demand those who speak to us, those with whom we give the power to make decisions over our lives, speak the truth. If you are trying to evaluate what the court is doing, what you read in the newspaper, do not accept it at face value. There are trusted sources you can go to, do your own research, make up your own minds. Do not accept what you hear on any station at face value, right? And one of my biggest problems is every news program no longer is news. It's a show. They even call themselves shows because they're there to entertain and make money. So independent of what your political views are, if you don't figure out the truth, you're never going to figure out anything else.
Alrighty then, since we're running out of time, we've got one question from Zoom, and I wonder if Hadley, you might be willing to take this one on. So the question is, does the act of birthright confer a freedom of descent that is ethically different from that of naturalized citizens? Then he added context. The citizenship clause of the 14th Amendment creates a single class of citizenship with equal rights and obligations. Naturalized citizens swear a vow to support and defend the Constitution, but this vow is not taken by natural-born citizens. Is this absence significant?
The absence of taking the oath.
Yeah, I guess the difference between naturalized and
It's making a distinction between naturalized citizens and citizens by birthright.
Citizenship. And I think this is one of our big issues right now. I think the Supreme Court, and I'm, the scholar side of this, I prefer that Professor Cioffi and Mort speak to this. I can just tell you right now that the birthright citizenship executive order was allowed to move forward recently by the Supreme Court. We don't know how it will play out because I believe the U.S. Department of State will interpret it. The Social Security Administration will interpret it. I'm not clear yet what the criteria will be for citizenship under this executive order. I believe it'll be at least one U.S. citizen born parent. I'm not sure about this. If anybody does know, I'm open to hear it because we're still at those initial stages. But I know that the 14th Amendment citizenship was more about giving citizenship to freed slaves. And the naturalization process is to give citizenship to people like you, the person who asked the question, who are not born in the US and who met the criteria of being permanent residents, for the physically present in the US, can pass a civics test, and those criteria that are met, they become citizens. I'm not sure that I understand the question, though, so I'm just listing the differences in birthright citizenship and naturalized citizens. So if anybody can help me clarify what the question is, I would appreciate it.
I don't remember the case name, maybe John will remember, but the issue of birthright citizenship was actually decided by the Supreme Court in the late 1800s, where we had a Chinese
Right.
born in this country to parents who were from China, and he left the country, and then when he tried to come back in, he was stopped. And the Supreme Court ruled that no, Having been born here, he was a citizen of this country. As I understand the current status of things, those who are in this limbo land that are being born right now before the case has been ultimately adjudicated by the court are getting their papers. They are getting their Social Security. And so a lot of us think that that's at least a detrimental reliance and that those will be okay. Now, once the Supreme Court rules, if they say it only pertained to slaves, well, we've gone down yet a deeper rabbit hole, but then I think that's only going to be prospective. I don't think those who are currently getting their papers would have them taken away.
But who knows?
Who
But-
knows? Yeah, because
okay.
I have heard it will be retroactive.
Okay,
knows?
there you
Yes.
go.
So.
Reasonable
we don't know-
minds differ.
I
and
know,
we're all
and it-
trying to
and it-
predict
There are only
the court
9
doesn't
minds
predict.
that matter on this.
Right, and
Birthright
That was an
citizenship, that's
executive
what it's always been, at least since the 14th Amendment, yes.
but there was an executive order that was made like in April or May that basically said that it is not automatic. And now we have different agencies interpreting that, and they all compete on their interpretation too, so that's going to be fun. Figuring out what the State Department requires and what the Social Security Administration requires and the USCIS requires, or who's going to be the actual, which agency is actually going to be the ultimate authority on it. We still don't have that ultimate authority on passports versus certificate of citizenship. They're competing documents that prove citizenship. So I believe it's going to be the same.
So
All right.
this will be a
We're
constitution.
running out of time, but yes, if you want to keep it short.
Yeah,
Mr. Cioffi.
I just want to say that this is actually also a good example of the manipulability and abuse of original intent and originalism. Yes, it's always been understood that if you are born here, it does not matter what your parentage is, you are a citizen. But one of the arguments being made is an originalist argument. Well, it only was written in response to the freeing of the slaves in the 13th Amendment and to reverse oh God, the famous slavery
Dred
case.
Scott.
Dred Scott, thank you. And so it should be limited to that, regardless of what has happened in the last 150, 60 years. Is it kind of a harebrained argument? Sure, it wouldn't have been, credited at all, 10 years ago. But here we are. It's a very different world. But it gives you an idea that originalism was designed initially to be a constraint on governmental and judicial power, and it's really not. You can do whatever you want with it. There's what's called law office history. You just ransack historical facts and find the ones that support your position. And if you can convince 5 members of the Supreme Court, that's good enough.
Alrighty then. Well, thank you so much. I'm sorry, sir, but we're wrapping up the event. But all right, thank you to our speakers. The discussion has been lively and it's gone a lot better than I imagined somehow. But you guys, I know it seems like everybody's really engaged, and I really appreciate you guys' contributions. I really appreciate the participation from the audience. Thank you. Thank you all. And that's it.
Thank you. Thanks.
I don't know if you guys will stick around. We're gonna need to have everybody leave the library as we clean up. But yeah.
How fast are you kicking us out?
If you guys want to stick around for a bit and chit chat, that's not a problem for me. Yeah, we have refreshments in the back.
Yeah, we
I'm
didn't
on
get
the
our
board.
cookies yet.
You guys can stick around for sure. But yeah, thank you so much.
Because of course, these people need all types of help.
Yep.
And